Hello everyone, welcome back to another episode of the Darrell Brooks saga. Today's episode we go to a new day. It's day 8. We're halfway through the trial now, so it's gonna be an exciting time. We're still going with the prosecution case, so we're gonna see what new information brings Mr. Brooks to the table after obviously going back with his coach, talking with him on the phone, see what else he needs to do. He needs to press on. Let's go right into it. Oh, but first, thank you for subscribing. We are now over 800 subscribers, which is awesome. And I would love to continue to grow with you guys, giving you more content, trying to give you these guys everyday content. So stay tuned for that. And another thing is that I'm gonna be traveling again. This month is gonna be hectic about my schedule for work. So subscribe if you wanna be on the loop to when the videos are gonna come up. Alright, let's go right into the video.
Good morning, Judge Sue Upper, Leslie Basie, and Zach Witchell appearing for the state of Wisconsin.
Good morning, sir. Your name for the record, please.
I'm here as a third-party intervener in that matter, appearing as authorized representative for my client. I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments.
We had
Alright, we still want that.
a discussion with Mr. Brooks outside the presence of the jury in which several broad topics were discussed. One of them was Mr. Brooks had indicated he did not have a pretrial offer from the state. We would ask the record to reflect that afternoon we did provide him again with a written copy of our pretrial offer, and that was placed with his materials on the table. I just wanted that in the record, please.
I object to that. I don't. If it was with my paperwork, I haven't seen it.
So he's objecting that he doesn't know because he hasn't seen it. So it might be there, but he just didn't care to look for it.
It was specifically one of...
Also, let's look at his suit. Like right now he's wearing the black suit with a grayish shirt and the bluish tie. I will give him a 6 out of that. I take 2 points off because it's him. I take 1 point off because the suit is too large. And another point off because I don't like that tie with that suit. I think it should be something that stands out more.
The paper, sir, that you left in the bullpen area, that on the next morning, on Friday morning, I made a record of providing back to you. So it was provided to you twice.
Twice.
Well, I haven't seen it.
So,
You want to put the offer on the record, Attorney
Yes.
Opera?
Give me 1 second.
I like that. I like that. Okay, they're saying, okay, so you don't want to read it? Fine, we'll tell it right now.
What's the significance of it being on the record? If
So that you are fully aware of it, sir. It was
Thank you,
provided
Judge.
to you, but you're indicating you haven't read it, so I want them to make a record of it. The significance would be, I suppose, if at any point you wanted to change your plea, you could do that based upon the pretrial offer.
well,
That's fair.
in any event, I accept for value and return for value that document whenever I see it.
Typical subset tactic, which by the way, I just need one more day or two. I don't know. I need to work on the schedule. It's been frantic for me these days, but you guys have all these questions about return for value, all the subset things that he does. And I'm working on a video explaining all of that. So be on the lookout for that video. I'm still don't know when I'm gonna get it out, but be on the lookout for that one. It'll be good.
Attorney Opera, go ahead.
Sorry, it's just taking me a second to retrieve it here, Your Honor.
It's a lot of paperwork.
Your Honor, this would be a perfect time to address the subject matter jurisdiction that has yet to be proven on the record and must be
Mr.
proven
Brooks,
by the prosecution.
we are not going to address that. I issued a written decision last week. If you disagree with that, then you can take that up to a higher court. But I issued a written decision. I'm not addressing that any further.
That has yet to be proven on record.
Mr. Brooks, my written decision is the decision of this court.
Has it
Attorney
been
Opera,
proven?
go ahead.
Has it been proven on record that you have subject matter jurisdiction? Because it has yet to be proven.
Mr. Brooks,
Doesn't need
your
to be.
position is simply not correct as a matter of law. I explained that.
Then prove it
and
lawfully
I issued
by
the
law.
decision. You might be
She doesn't need
confusing
to.
subject matter jurisdiction with venue, which is why I commented on that last week.
Absolutely
And there
not.
has been evidence received regarding venue. So I'm going to turn back to Attorney Opera.
has nothing
She's
to
going to
do
make
with
a
venue,
record
Your
of the
Honor.
pretrial offer. I'd ask that you not interrupt. Thank you.
Plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts. The defense is free to argue. This pretrial offer was conveyed to his prior counsel on or about the July 5th date, and there in fact had been a earlier offer as well that had been relayed prior to the preliminary hearing or the filing of the information back in January of 2022 that had also been conveyed to his defense counsel at the time.
All right, thank you.
So why?
Right, so he was done either way. So even with all the enhancers that they took out, all the domestic that they've been that they took out, he was still going to be 6 consecutive life sentences. So he was done. I think this is the main reason why he wanted to go to trial, because he was done either way. So why not?
I haven't I been informed of that?
You've been informed just now, sir.
All right, Mr. Brooks, that is not a topic we are going to take up any further. I just wanted the record to reflect that offer was conveyed to you.
It wasn't conveyed to me, Your Honor.
It was just conveyed.
This is the first time I'm hearing of it. So if it was conveyed to my former
It's
counsel,
not something I'm going to. It's not something I'm going to further address, sir, unless you indicate to me that you would like to take advantage of the pretrial offer by changing your pleas to either guilty or no contest to counts 1 through 67 and submit the appropriate paperwork. I'm guessing that's not what you want to do.
Yeah.
So unless that paperwork were to be filed, then I'm going to continue with this trial as if you are exercising your right to a trial in this matter.
in all respect, Your Honor, I don't think it's fair that you should assume what I want to do or not, or what I don't want to do.
I just need to make a record that that paperwork was provided, sir. We'll continue with the testimony today. I'm not going to take up subject matter jurisdiction. I've issued a written decision. Is there any other preliminary topic from either party?
Is
Mr. Brooks?
that decision verified proof that subject matter jurisdiction exists? Because it has
It's a
yet to
ruling
be
about-
proven on the record.
All right, your objection is noted.
It's not a. They don't need to prove it, my guy. And also, she gave you a paper that you can take to the appellate court and then dispute that. So, what else do you want?
Please bring the jury out.
Your Honor, is that the answer?
Yeah.
Mr. Brooks, I issued a written decision. That's your answer.
And what's that? And what does the written decision entail?
Read it.
So that was provided to you last week. I'm not going to
I
go
accept
through it
for
again.
value in return for value the document that I have not seen. What does it entail, Your Honor?
Read it.
Sir, you were provided with a written copy. I'm not going to read it into the record at this point. It is part of the record. It's a final order
If
for
it's
purposes
part of the record,
appeal.
why can't it be read into the record right now?
It doesn't need
It
to be read
wastes
into the
time.
record. Sir,
Is it
it's
verified
part of
proof
the
of?
record.
Is it verified proof of subject matter?
Mr. Brooks, I'm not answering that because it's not something that needs to be verified.
It
have a
it
mistaken
has to be
belief. All right,
verified
is
by
the
the
jury
prosecution.
Then why are you asking
Or is that a
her
tacit
for proof?
agreement that you don't have to answer that question, or verify proof of subject matter
Sir,
jurisdiction?
I have no such agreement with you, tacit or otherwise. So
She said it right.
that's
Tacit.
not how this operates. Again, just
So
because
would
you
it be
believe
proven?
the law requires, that doesn't make it true. All right, the jury's
Show me
coming out.
lawfully
All
law.
rise for the jury, please.
Show me by lawfully law that you have subject matter jurisdiction, because it hasn't been proven on the record. It has yet to be proven for the record. Let the record reflect that.
The record will not reflect that, and the jury will disregard the comments currently being made.
The record
just
should
made by
reflect that.
Mr. Brooks.
It doesn't.
You have to put it on the record.
Nope.
Otherwise, that'd be tampering with the record.
She's accusing her of tampering with the record. That's big words, my guy.
So at 8:40.
All right. Good morning, everyone. Please be seated.
Tacit agreement at 8:40.
Tacit agreement.
All right. Please disregard the most recent
just ignore
comment
this
by
guy.
Mr. Brooks. It's not evidence in this proceeding.
Good morning, Mr. Backler.
Hi.
Sir, on November 21 of 2021, where did you live?
Objection, relevancy.
It's establishing
Around
the subject.
4:49 p.m. What happened, sir?
Objection, leading the witness.
Overruled.
I heard some noise around on the east side of my garage, and I went to see what was going on, and I found the defendant on the side of my garage.
And you questioned that person for being there, is that right?
Objection, leading the witness.
That's kind
I
of
think I dropped an F-bomb on him.
Why?
He was trespassing.
Okay. The person that
It
you
was an objection, but it's overruled.
the person that you saw, can you give us a description of that person, please?
When I called it in on the non-emergency line at the Waukesha Police Department, I described him wearing a red shirt, jeans, long hair, beard, and I think he was missing his shoes.
Okay.
that's it.
Did you said red top?
Red shirt.
Objection,
Yes.
leading the witness.
Red shirt. What
not
kind of
red.
shirt?
Overruled.
I believe it was a red T-shirt.
Okay. To your way of thinking, was he dressed appropriately for the weather?
Objection, leading the witness.
Overruled. You may answer.
Relevancy, objection.
Overruled.
Miss again.
Immediately, it just seemed off because he was wearing a T-shirt. If I remember correctly, he was not wearing shoes. It was very cold out. He was sweating. His eyes were huge, and he kept asking if I could call him an Uber, and then he said, "I need to get home."
Did you agree to call an Uber for him?
No, I said he needed to leave my yard.
Okay. Do you see him present in the courtroom here?
He's sitting over there with the mask on and in the suit.
Okay, I'm going to ask the defendant be instructed to remove the mask.
Mr. Brooks, please remove your mask.
And if he would look at the witness, please, Your Honor, with his head down, it's not to assist him.
All right, Mr. Brooks, please look up and look at the witness.
The
Look at the
witness.
witness, please.
He knows. He knows this witness saw him. But that's why he was so sneaky about putting off this mask, because he knows he's going to recognize him.
Is that the man
recognized
that
the
you're
witness.
describing that was in your backyard that you spoke to?
Objection,
Yes.
leading.
Overruled.
Move to admit and permission to publish 171, Your Honor.
Objection, relevancy.
Your objection is overruled.
And sir, it's a little hard to tell in the photograph, but was the T-shirt he was wearing a short sleeve or long sleeve, if you remember?
Objection, relevancy.
Overruled.
It was a short sleeve shirt.
Okay. Ultimately, did he leave your property?
Objection, accident, answer.
Overruled. You may answer.
When he was leaving, he was kind of taking his time, and then I told him he needs to leave again, and started walking towards him as he was leaving, and he lifted his shirt up and said he was unarmed.
Okay.
So,
Had you asked him about any weapons?
I had not.
Objection, relevancy.
Overruled.
I had not asked.
Thank you, sir. I don't have any other questions.
really
All right.
short witness, just establishing what happened. He saw him. He ran away. Now, let's see how long it takes for Brooksy to tell us to ask this witness questions.
Mr. Brooks, do you have any questions for this witness?
Yes, I do, and I object to being called that name for the record.
Deal with that.
Do you recall giving a statement to Officer Probst?
I don't know his name, but I've talked to an officer.
So it was a conversation on the non-emergency line. Would that be fair to say?
It was on the non-emergency line. I actually confirmed it after I called to make sure I was on the non-emergency line.
Do you recall the description that you gave at that time?
I do. Well, my best of my knowledge was that you were either black, Latino,
Who's you?
or mixed.
Who is you?
Hold on, you have to let him answer the question first before you
Always with the
interrupt him with
question.
another one. Go ahead with the description you provided that night.
I said that the individual was either black, mixed, or Latino.
Makes sense.
So it would be fair to say you didn't know at the time.
No.
I was giving a general description.
So it would be fair to say that you weren't sure.
I was positive that it was you.
Who is you?
You. I'm looking at you.
I'm looking at you. Nice. He doesn't know what to respond to that.
And how did you come to that conclusion, the you conclusion?
I'm looking at you.
I'm looking at you.
How did you come to that conclusion? Did you?
What conclusion?
Because
Can you restate the question?
You're saying that you gave a description on the non-emergency phone line, correct?
It was on a non-emergency line.
So it would be fair to say at that time you had no name or knowledge of who the person was in your backyard. Would that be
Never
fair to
said
say?
any name.
I had no idea who you were.
And so how can you say how can you say you then if you had no idea?
I'm looking at you. You were the guy.
And how,
Darrell Brooks is using the old tactic of right now. He's talking about right at that point, not right now. The witness is like, yeah, I'm looking at you. I know who you are right now. And Darrell Brooks is at that point in time, in that second, did you know my name? So he never says his name.
how did you come to that conclusion?
You and I were standing in the same yard looking at each other.
So is it possible you saw something on the news?
What?
No, I had no idea who you were.
Interesting. Do you recall giving a description of approximately 5'9" and 160 pounds?
Yeah, something like that.
That's a guess. But remember, you never give Darrell Brooks an estimate because he's gonna rake you over the coals for that. It's gonna be like, is it not 5'11" maybe? You didn't know.
Something like that, or would that be accurate?
I didn't have a tape measure out. It was just a guesstimate.
Good answer.
Would it be fair to say that since you keep identifying me as you, would it be fair to say that I'm not 5'9" nor 160 pounds?
Do you have your shoes on or off right now?
Nah, I think Darrell Brooks is really tiny. He's like 5'6" to me, and maybe 120. He's small.
Would it be fair to say that I'm not 5'9", 160 pounds?
If you take your shoes off and step out of them, they could have a better.
I'm not going to have them do that, but if you're able to answer the question, do you agree?
I'd
or
have to be
disagree?
standing next to him. That's what I made my judgment from. We were about 2 feet from each other.
Does it look like I'm 5'9"?
I don't know. We were a lot closer.
Does it look like I'm 160 pounds?
Objection.
Grounds?
It's irrelevant as to his appearance today, just like his hair isn't in dreadlocks today.
Sustained.
Objection.
Question.
Grounds for the sustain. You also said that, well, the narrative in the report said that the individual was later identified. Would that be fair to say?
Yeah, that'd be fair to say.
And so would it also be fair to say that because the individual was identified later, that's how you came to the conclusion of who it may have been in your yard?
Objection, I think that's
Grounds?
a statement, Your Honor. He's, again, reading a police report,
That's a question.
not authored by this witness. It's beyond the scope of the witness's knowledge.
It's actually the report that he
Mr.
gave.
Brooks, I've heard enough. If the objection is sustained.
I don't need you to explain it, bro.
Did you follow the investigation after you had given the report on the non-emergency line?
It's kind of hard not to see it on TV.
So you made reference to it was kind of hard not to see it on the news. Would that be fair to say?
He was all over the news.
And would it be fair to say that from those news reports you gained additional information that you didn't have that night?
Actually, what I did is went into work the next morning and pulled up the police report on the internet, and there you were in a mugshot. And I'm like, that's the guy.
That's the guy.
So you got a further description from a mugshot?
No.
No, I didn't get a further description. At the time, I didn't care who you were when you were in my yard. I didn't know who you were, what you had done, where you had been, any of that stuff.
So
all I'm saying is you were trespassing in my yard at that time. And that's all I can say. Other than that, that's all I can confirm. I don't know what you did. I don't know where you were. I don't know any of the other stuff.
Yeah.
All I know is you were the guy in my yard.
The guy that you said was 5'9", 160 pounds.
Approximately.
Objection, argumentative,
Grounds.
asked and answered.
Grounds.
Sustained. Next question, you don't have to answer that.
And what prompted you to read or pull up the police report?
Objection, irrelevant.
Grounds. He said it. He brought it out there.
Overruled, he may answer.
I was curious of actually who you were. And if you were the person that actually had done the atrocities that were on television.
And what prompted the curiosity?
A stranger was in my yard, unannounced, trespassing, asked him to leave, and they ended up catching somebody for doing something very bad, and I was wondering if that was the individual that had cut through my yard.
Yeah, that makes sense. I would be curious as well.
So it'd be fair to say at the time you wasn't privy to that knowledge yet. Grounds.
Sustained as to the form of the question.
At the time you pulled up the police report, as you say, you had no knowledge of the identity of the individual.
I didn't know that you were going to be the person that had done that.
You keep referring to the you.
You. I'm looking into your eyes right now. You're the guy I'm talking about when I refer to you.
And the record should reflect that the witness used his right hand and index finger to point directly at the defendant. Next question, please.
Good witness.
So you just made reference to looking the you in the eyes, but you would need...
What would you prefer I call you?
You would need...
Because you're not going by Darrell Brooks.
You would need me to step out of my shoes to tell my height and weight, right?
I'd have to also stand 2 feet from you.
Hold on, please.
They're going to fight.
Mr. Brooks, you're directed under 90611 to ask a question and not argue with the witness.
That
Thank
was
you.
the question.
It was argumentative. Please rephrase your question, and then the witness is instructed to wait until a question is...
Is he really that mad about him, like, describe him a little bit taller and a little bit fatter? Is that it? Is it just because he's calling him fat or something?
Asked, and if there's any
160 is
objection,
not
then I
fat.
will on it first. Go ahead, next question.
It sounds like he the one arguing.
Last comment, Mr. Brooks.
How
you're next.
old are you, my guy? You're in the courtroom fighting for your life, and you're like, oh, he wanted to argue with me, so I'm just arguing with him, Mom.
Testifying right now. You'll have an opportunity if you choose to do that later. Please ask a question.
Yeah, I'm going to get to it.
Do it then.
Any reason why you didn't give a written statement to law enforcement?
Objection, argumentative,
Grounds.
irrelevant.
How's it argumentative?
Sustained. As to the form of the question. Next question, please.
Did you at any time give a written statement to law enforcement?
I don't believe so.
No.
Any reason why not?
Objection,
Grounds.
argumentative, and
He already
irrelevant.
did a report.
Sustained.
Grounds for the sustain.
Mr. Brooks, please ask your next question.
Grounds for the sustain. You said you pulled up the police report at work the next day, right?
No, I pulled up your mugshot.
Well, you did say police report. Would that be fair to say?
I just pulled up a mugshot.
You don't recall saying that you pulled up the police report specifically?
I specifically wanted to pull up the picture of the person that had committed those atrocities to see if that was the person that had cut through my yard, which confirmed it was.
Have you yourself filed a complaint?
Nope.
Here we go with the plaintiff questions. He ran out of time. Ran out of questions.
Any reason why not?
Objection.
Grounds.
Relevant.
Sustained.
Argumentative.
As to the form of the question and on relevance. Next question.
So you knew it was a possibility that you would be called to testify?
I had no expectation of the subpoena until I went to the DA's office.
So you went to the DA's office?
They want to see if you're worth having as a witness or if you actually had any information that was pertinent to the case.
And so would it be fair to say that you felt that you did?
I didn't know.
Grounds.
I'll sustain as to the form of the question that strike the last response. Please rephrase.
Did you feel that you had information that would be relevant to the matter?
That's an irrelevant question,
Grounds.
Your Honor.
Sustained.
Yeah, he's
Next
testifying.
question, please.
It's relevant.
Grounds for the sustain, Your Honor.
Next question, please.
Grounds for the sustain, Your Honor.
Next question, please.
Is that a judicial determination, Your Honor?
Move on.
Ask your next question,
Cut him off.
please.
Just cut him off. He's gonna go into the plaintiff next, I'm sure.
When you went to the district attorney's office, do you recall whom you spoke with?
I don't recall their names. I recall their faces.
You said you do recall the names, not the faces?
No, I recall their faces, not their names.
Oh. Do you see any of those district attorneys in court here today?
I see one district attorney and one officer was in the room.
Right? Oh? But what's the point of that?
And for the record and for the jury, can you identify whom you're referring to?
I'd have to point.
I'll
Her,
stipulate,
yep.
Your Honor, I met
And
with Mr. Backler.
this officer here, sitting behind them.
All right, so the
Yes,
witness has
Detective.
pointed to District Attorney Sue Opper and Detective Casey.
Alright, so?
Do you recall ever being told about the plaintiff in this matter?
Here we go.
Objection
Grounds.
vague.
Sustained as to the form of the question.
Cut him off, please. Cut him off. It's a waste of time.
Do you know who the plaintiff is in this matter?
Objection
Grounds.
vague, beyond the
Grounds.
scope of the witness's knowledge, legally inaccurate.
All of
Sustained
those
as to the
grounds.
form of the question.
Did Attorney Opper ever tell you who the plaintiff was in this matter?
The subpoena told me who the plaintiff was.
And do you recall who the plaintiff is?
Darrell Brooks.
That's the plaintiff?
Or not the plaintiff, the plaintiff is, I think, city of Waukesha or state of Wisconsin, I'm not sure.
And it'd be fair to say that that's not a living, breathing human being.
Objection
Grounds.
relevance.
Sustained, not relevant. Next question.
Next line of questioning, please.
Are you aware that only a living, breathing human being can make a claim?
Relevant.
Objection
Grounds.
irrelevant. Argumentative.
Grounds.
Sustained for those reasons, and it's also not an accurate statement of the law.
Definitely not argumentative.
Mr. Brooks, under 90611, I need you to move on from this
Thank you.
topic and ask a different line of questions, please.
Move on from what topic, Your Honor?
What topic are you
Next
talking about right
question,
now?
Can I know what topic you're referring to, Your Honor?
What is this what is that? He's playing dumb. He's just playing dumb. Like, you're just talking about the plaintiff. How do you know You don't know
Next
what
question,
topic is?
If I don't know the topic, how would I know to go in a different direction?
Mr.
Because-
Brooks, under 90611, I need you to ask a question.
Just cut him off. He doesn't need to ask any more
Do you
questions.
know if there's even a plaintiff in this matter?
Cut him off.
Objection, irrelevant.
Sustained. Under 90611, sir, please move on from this topic or I will declare your cross-examination closed.
Under what law and fact, Your Honor?
Under 90611, please ask a question.
And where can I find 90611?
This is your last opportunity to ask a question, sir.
Your Honor, the jury deserves to know this information.
All right,
90611?
then the state, any redirect?
No redirect. Thank you, Judge.
All right, thank you, sir. You may step down.
Are you home on the
Alright, I'm sorry. I'm gonna cut this video short because the power has been going off in my house today. There's a lot of wind, so I'm gonna try to come back tomorrow with a longer one. But thank you guys so much for watching. I'll see you guys tomorrow. Give it a like if you made it this far. Subscribe if you're not subscribed, and I'll see you guys next time. Have a great day.